I hope you can hear me well.
We can hear you, my lord.
Thank you. We are going to do a hybrid so that we utilize the tools we have, including technology for swift delivery of justice. The matter before us today was for highlighting of some issues, which was agreed upon by all the parties. And after wide consultation and consensus building among us, ourselves, and the parties, and we realized the urgency of the matter, hence today's date. So I hope everybody is ready so that we can continue with the highlighting and complete the matter with the speed that is required of us as ministers of justice. So I will call upon Senior Kalonzo to introduce his team.
Thank you, my lord, my ladies. I appear together with my colleague Eugene Wamalwa, Council Soyinka Lempa. We are so happy he's not appearing virtually. He has always had some difficulty, but he's here physically today. Councilor Wajiru, also on record, but he's traveling between Nairobi and Kilifi. Should he catch up? He's also on record, my lord, my ladies, and Councilor Stephen Zaku.
Yes, my ladies and my lordship, I'm present.
That's all.
Okay. John Ohaga.
Good afternoon, my lord.
Oh, no, there's Professor Ogola. Sorry for that. Professor Ogola.
I haven't seen him this afternoon, my lord.
Okay. So Professor Ogola, we mark him absent, eh?
There were two other petitioners.
So Professor Ogola absent. The other two petitioners? Karanja is present.
Kahara Masharia. Samuel Kahara Masharia. Gaona.
Okay, Kahara Masharia. One petitioner present. Yes. The other petitioner? The other petitioner is absent. All right. Now we go to John Ohaga and your team. Please introduce him.
Good afternoon, my lord. Good afternoon,
Good afternoon.
Good afternoon, your leaderships. I appear together with Mr. Christopher Marwa
Yes.
and with Ms. Leila Ahmed.
Present, your Richard.
Miss?
Ms. Leila
Leila.
Ahmed
Okay.
for the first, second,
And
third, I beg your pardon, first, second, fourth,
not third, eh?
not
Fourth.
third, not third. First, second, fourth,
Yes, fourth.
fifth,
Fifth.
ninth,
Ninth.
10th,
Tenth.
and 11th respondents.
And 11th respondents.
Mr. Innocent Muganda
Yes.
is on record for the third respondent.
With Ms. Kumu, my lord.
Together with Ms. Kumu,
All right. For third respondent.
Mr. Andrew Musangi,
Sange. For.
and Ms. Rachel Nderu appear for the 6th respondent.
6 respondents.
Mrs. Aisha Abdallah.
Aisha Abdallah
Appears for the 7th respondent.
My Lord, together with Ms. Amayo,
Together with Ms.
Mayo.
Georgina Amayo. Together with Ms. Georgina Amayo.
Okay, Miss Amayo and Miss Aisha, they are for 7 respondents.
That's right, my Lord.
Yes.
And Mr. Kevin McCourt, Senior Counsel,
Yes.
appears for the 8th respondent.
To the court physically.
Okay. Present. Yes. Any
I
other representation?
covered all the parties. I think I've covered all the parties appearing.
All right.
No, my Lord, there's still the 12th respondent.
Mr.
my Lord, yes, Mr. Ismail. Mr. Ismail is present for the 12th respondent.
Ismail for 12 respondents.
My Lord, we are on our way to court physically.
Yeah, no problem. So Ismail for 12 respondent present. I have nothing.
Thank you very much, my Lord. That's
Okay.
the appearances for the respondents.
Okay. All right. Today was for highlighting of some issues. Senior Kalonzo, are you ready on your part?
Yes, my Lord, we are ready.
John and your colleagues?
I beg your pardon, my Lord.
I'm saying John and your colleagues, are you also ready for highlighting?
Yes, yes, we are ready, my Lord. We are ready.
Thank you.
So, Senior Kalonzo, how much time do you think you require to complete your submissions?
30 minutes, my Lord.
30 minutes.
We propose to proceed in the following manner, my Lord, my ladies. I will make some opening remarks, and I will leave Counsel Lempa to do the detailed presentation or highlighting.
Okay.
As soon as I'm finished, my Lord, my ladies, I will quietly exit. It should not be seen as a mark of disrespect to this court.
All right.
And so we are ready to proceed, my Lord.
Okay. That's quite in order.
So,
yes, you can continue.
thank you. Thank you.
Proceed, Senior Kalonzo.
Thank you. My Lord, my lady. Following your ruling, which granted the petitioners conservatory orders,
Yes.
our colleagues appearing for the state and the other respondents proceeded to the Court of Appeal.
Yes.
And as we meet this afternoon, we understand that those conservatory orders were set aside. So, my Lord, my ladies, you will recall our argument that time that we would not want this matter to be reduced to an academic exercise, our fear then, and that fear remains valid, and complete this transaction
Yes.
But you also note that their lordships, the appeal court judges, also made it clear that the mandate of this court
Yes.
is not interfered with, and that you, upon hearing our submissions today, will be at liberty to make a decision we believe will be in the best interest of this country.
Yes.
So, my lord, my ladies, we argue that the shares, subject shares numbering over 6 million, I think the precise figure is 6,009,814,200, comprising as they do complete
Yes.
total 35%. Now, the Kenya government shareholding, if this transaction was to go through, will be reduced from 35% to a paltry 20%.
Can you hear me?
Yeah.
Also, I cannot hear you.
You can hear me, my lord?
Yes, now
Yeah, you
I
can.
hear you.
Thank you so
You're
much.
saying-
And therefore,
Yes.
the reduction from 35 to 20%, reducing therefore the Kenya government shareholding to a minority. In fact, they will lose even the number of seats in the board. And the country gets to a situation where the respondents become, or some of them at least, further upon, I still remain a little bit at sea on exactly some of these relationships, and I know, my lord, my ladies, will be able to demystify these shareholding relationships, but the respondents must be 6 billion. Wow. My lord, my ladies, I'm corrected. It's not 6 million.
Yes.
It's 6 billion. 6 billion
6
shares.
billion.
6 billion shares.
Okay.
So that the respondents then become monopolistic, almost near monopolistic. And my lord, the Privatization Act number 18 of 2025
Yes.
at Article 22 D
Yes.
and E, 22 sub Article 2 D and E, the Cabinet Secretary is supposed to take into consideration, among other issues, and want to highlight just two: the national security interests of the country at D, and at E, the need to avoid a privatization that may result in a monopoly.
Yes.
My lord, my lord, my ladies, we argue that the shares have been grossly undervalued
Yes.
and we rely on the expert opinion of Mr. Nyakera.
Right.
I believe this has not even been controverted.
Yes.
And so, secondly, my lord, my ladies, our argument is that the transaction advisors
Yes.
were irregularly procured without any competitive bidding.
Yes.
Our third point, my lord, my ladies, is that the expected sale proceeds, that using the expected sale proceeds as revenue contravenes Articles 209 to 214 of the Constitution.
Yes.
My lord, my ladies, the Cabinet Secretary failed to submit to the National Assembly a privatization program contrary to Articles or Section 22, I believe, Section 22(2) of the Privatization Act.
Yes.
My lord, my ladies, we also argue that there was absence of public participation, a cardinal requirement in our country as it is today.
Okay.
And then fifthly, my lord, my ladies, failure to consider national security interest. In the sessional paper, as I said earlier, in breach of Section 22(2)(d) of the Privatization Act of 2025.
Yes.
Security, my ladies, is critical. This country is gearing itself for an election year next year. Transmission of election results normally is done through Safaricom and all. Never mind, my ladies, sometimes they've been misused to give information regarding the now notorious abductions that have been visited upon the population of this great nation.
Okay.
So, my lord, the many agents, mama boggers who rely or do their transactions in the millions, we had occasion to highlight that my lords, my ladies, in our earlier submissions,
Yes.
we stand to suffer a measure of being dispossessed of this vital national asset, which will now clearly be foreign owned. Through the Vodacom group.
Yes, continue.
My lord, my ladies, I now yield the floor to Council Lempa to continue with the highlights.
Okay.
I thank you.
Okay, thank you very much, Senior Counsel. Lepa, and be precise and do not rehash what you have already written. Give us the specific details which you think that would require our attention.
Yes, thank you.
Lepa, continue on that basis.
Thank you, my lord, my ladies. Our amended petition is dated the 22nd day of April 2026. It is supported by the affidavit of Kalonzo Musyoka,
Yes.
dated the 16th day of June 2026. Further affidavit.
Yes.
My lord, it is also supported by the affidavit of Ilongo Nyakera. Ilongo Nyakera, I'll get the date. I'll get the date, my lord. And the submissions, our detailed submissions, dated the 16th day of June 2026. My lord, and before I proceed, I would like to bring to your attention, and under section 60 of the Evidence Act, that this court should take judicial notice that today Safaricom share was selling opened at 34 shillings and 40 cents. 34 shillings and 40 cents. That is judicial notice. And therefore, courtesy of your conservatory orders and the status quo orders by Justice Mugambi, your brother, this country has been saved of 2.4 billion shillings today. The money that John Bandigongo and Dorcas Oduor Agik Odong wanted to throw away. My lord, without necessarily rehearsing on what my senior counsel has said, our submissions have a number of parts. We have the fact from paragraph 1 to paragraph 57, where we begin the analysis. But my lords, my ladies, we would like this court to take close attention to paragraph 2 of the written submission, where the divestiture sessional paper states that they want, or the objective of this divestiture, of this ignominious divestiture, is to raise revenue. My learned senior counsel has elaborated that the Constitution under Part 3 does not allow John Badingongo and Dorcas Agik Oduor to raise revenue using Part 3 of the Constitution. That is in paragraph 4. My lords, my ladies, would also like you to pay closer attention to paragraph 5, where the sessional paper in paragraph 1.72 describes the would-be purchaser, the said shares of Vodacom Group, the seventh respondent, a foreign entity wholly owned and controlled by unknown shadowy persons. Watu ambao hawajulikani. shadowy person. While
Council, are you referring to the submissions of
Yes.
the petition?
submission,
Submission.
yes. Paragraph.
Do you mind repeating what the Constitution does not permit?
The Constitution does not permit the state to raise revenue using Part 3 of the Constitution. It is well elaborate. It will come clear as we go to specific details to that. But we are saying that on paragraph 5, the first respondent section on paper, which is paragraph 1.72, describes the would-be purchaser of the same shares as Vodacom Group, which is the seventh respondent, as a foreign entity wholly owned and controlled by unknown shadowy person. While, on the other end, the press release dated the 3rd day of December 2025, which is annexed to the affidavit of Tony Gachoka, of the supporting affidavit dated the 22nd day of April 2026, projected the eighth respondent being the Vodafone Kenya Limited, as the would-be purchaser. They are introducing a purchaser by a press release, not in the sessional paper itself. Hello? Going down there, it is very clear that the way the respondents have treated this particular divestiture it's shrouded in mystery. You know, my learned colleague, my learned senior, wishes to challenge expert opinion on a technical issue, the ordinary and proper course is to adduce contrary expert evidence and mere assertions by counsel or lay witnesses, like John Badimongo is a lay witness, like Dorcas Odur Agik is a lay witness, are generally insufficient to displace a properly founded expert evidence. So that the question we pose, is the evidence of Irungu Nyakera a properly founded expert evidence? Yes, it is. Is Dorcas Odur Agik an expert witness? No, she is. She isn't. No, she isn't. Is John Badingongo an expert witness? Indeed, he is not. And therefore, we urge this court and we submit humbly that you treat the entire expert witness by Mr. Irungu Nyakera, who is a financial engineer, as uncontroverted. And the uncontroverted evidence, my lords, my ladies, is nothing but evidence of how the state has undervalued the shares of Safaricom company, the shares that they hold in trust for the people of the Republic of Kenya. Safaricom is not your ordinary telecommunication company. It's a strategic sovereign property whose divestiture cannot be done at the speed that John Badingongo and Dorcas Odur wants this court to adopt. in our part B, we have raised the following questions for determination: whether the government can use Part 3 of the Constitution of Kenya and Section 74 of the Privatization Act to raise revenue as per the objective of sessional paper number 3 of 2025. That is well elaborated, and I don't wish to meditate on what has been written. It is well explained from paragraph 31 all the way to paragraph 57, with well cited cases from both the local jurisdiction and international jurisprudence. My Lord, I think we have quoted the case of South Africa to support how this government or this particular regime is not allowed to create its own way of raising revenue outside of the Constitution, Part 2, Article 209 of the Constitution of Kenya 2010, which some of the proponent of this particular divestiture opposed vehemently, the Constitution of Kenya 2010. As to whether the proposed sale of government shares in the 6th respondent violates Article 1 because of the sovereignty of the Kenyan people, Article 10, people participation, and in people participation, my Lord, paragraph 76 is very clear, and it is even very sad that John Badingongo did not conduct public participation in his Suba county, in his Migori county where Suba constituency is. He did not. While we could, my lords, my ladies, is nothing but evidence of how the state has undervalued the shares of Safaricom company, the shares that they hold in trust for the people of the Republic of Kenya. Safaricom is not your ordinary telecommunication company. It's a strategic sovereign property whose divestiture cannot be done at the speed that John Badingongo and Dorcas Oduor wants this court to adopt. But in our part B, we have raised the following questions for determination: whether the government can use Part 3 of the Constitution of Kenya and Section 74 of the Privatization Act to raise revenue as per the objective of sessional paper number 3 of 2025. That is well elaborated, and I don't wish to meditate on what has been written. It is well explained from paragraph 31 all the way to paragraph 57, with well cited cases from both the local jurisdiction and international jurisprudence. My Lord, I think we have quoted the case of South Africa to support how this government or this particular regime is not allowed to create its own way of raising revenue outside of the Constitution, Part 2, Article 209 of the Constitution of Kenya 2010, which some of the proponent of this particular divestiture opposed vehemently, the Constitution of Kenya 2010. As to whether the proposed sale of government shares in the 6th respondent violates Article 1 because of the sovereignty of the Kenyan people, Article 10, people participation, and in people participation, my Lord, paragraph 76 is very clear, and it is even very sad that John Badingongo did not conduct public participation in his Suba county, in his Migori county where Suba constituency is. He did not. While we could actually forgive him for not conducting it where I come from, in Narok, because it is there. and Lamu. But of course, we know these are traditionally marginalized counties. But John Badimomo did not even conduct people participation in his own county. I don't know where Dur comes from. Maybe my good Richard Marwa can tell me, but I suspect he did not also conduct. She did not also conduct public participation. My lord, my ladies, we are highlighting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 counties. 17 counties, no people participation was conducted there. And there is no village in this country where there is no M-Pesa shop. And we are being told, they are glowingly talking about how effectively we conducted people participation. It's a lie. And it is a lie by John Badimomo to Parliament and to this court.
Yes, continue.
My lord, from paragraph 104 is to whether the impugned transaction complied with the mandatory requirement of the Privatization Act 2003 and Public 2005 to 2025 and the Public Procurement and Asset Disposal Act 2015 and the applicable Capital Markets Authority. We have quoted cases and we have given facts as defined by our petitioner and expert witnesses that this indeed was done wrongly. Lord, we proceed. We have quoted cases, we need not rehearse them, they are in black and white.
Yes, may I continue?
My Lord, insofar as the divestiture of 15% of the Safaricom company is concerned, we are saying that the government does not, just as they were advised by the Law Society of Kenya and they ignored that particular advice, that they are not allowed to sell companies that are profitable. The only window that are given to them is for them to sell unserviceable, obsolete, obsolescent, and surplus assets, of which Safaricom PLC is not part of. Lord, in our paragraph 144, whether the transaction unlawfully undervalued the strategic national asset in valuation of constitutional principle governing prudent public management and protection of public resources. We have exhaustively explained that, and we have exhaustively indeed demonstrated how Article 10, Article 201 have been violated. Lord, I wish, I hope, I wish to refer this court to paragraph 149 on what the expert witness said about an evaluation. In 149, he says the transaction of Kenya price 34 per share is materially below the fair value of Safaricom PLC as at December 2025. My weighted central fair value estimate at Kenya shillings 57.90 per share, with the range of Kenya shillings 47 to Kenya shillings 77. The discount of Kenya shillings 23 or 43% represent foregone proceeds to the public of Kenya approximately Kenya shillings 1.3 billion shillings. That is what the Kenyan people whose shares are held in trust by the state is losing. Going to our paragraph 148, whether the intended transfer of effective majority control over the six respondents threatens Kenyan sovereign national security competition framework. My learned colleague, Senior Counsel Kalonzo, has explained that, but if you want to get the finer details, you get it from paragraphs 148 all the way. My lord, my ladies, you will be persuaded that the shares that we are talking about are floated in the Nairobi Security Exchange, and any one person can buy. My lord, we continue arguing that a secondary IPO would have sufficed. And our argument to this fact is that a secondary IPO would be even cheaper than the market price. And the Kenyan people, including the generation Zoomers or Gen Zs, who are not mature, by the time Ilongo Nyakera, our expert witness, opened Safaricom IPO in 2007, were not mature. It is the desire of the Gen Z to have a bite at the cherry. Hata wao wapate nafasi ya kumiliki kampuni hii ya Kenya ambayo inamesewa mata na serikali ya Rais Ruto. Do not disregard any persuasion that these shares, even if they are floated, will be bought by foreigners. At least they have disclosed that indeed we intend to sell this company to foreigners. And in those few remarks, I invite my good friend and colleague, Mr. Zaku, to summarize.
Yes, my ladies and lordship, I associate myself Mr. Zaku.
Zaku.
Yes, my lord. I
Can you summarize?
associate myself with submissions by my senior colleagues. And what I'm saying is that, my lord, we are selling this company to a foreign entity. That is what it is desired. And to sell such a company to a foreign entity, it is a company which holds very sensitive data of the petitioner and 50 plus other Kenyans, or 50 million, who hold a Safaricom line. My lord, that information for every registered SIM card holder is protected under Article 31 of the Constitution, that such information which is tied to the shares in Safaricom cannot just be transferred to a foreign entity. This court, differently constituted, and as recently as on 19th March 2026, in the case of Erastus Bura of Thiambo versus the state, petition number E290 of 2024.
Sorry, are you introducing some new authorities that have not previously been cited?
I am guiding the course.
My lord, we're here to highlight submissions which rely on authorities to which we have had prior notice. He cannot just decide that he will introduce his own authorities at this stage.
Yeah, my learned colleague Mr. Zaku is an officer of this court, and he cannot be gagged. He cannot be gagged from introducing an authority.
Yes, my lord.
Zaku.
Yes, my lord.
Zaku, did you find that authority?
That's, my lord, is a recent authority. We've not filed it, but it's a key authority in this matter, that the court cannot ignore it. This is a court of law,
So,
and it's guided by
no,
the law.
we have noted it, but don't submit on it because the other council will not have an opportunity to reply to what you are saying.
Very well.
Continue on the other aspects.
My lord, we have said that that digital data held by Safaricom, it's an information that cannot be transferred to a foreign entity, and as such, that would be my submission as regards that issue of data protection.
My lord,
Is that all, Zaku? You are completed?
Yes,
yes, and to cap it,
Okay.
to carpet, my lord, my ladies.
Yes? That's Senior Kalonzo?
Yes, yes, my lord. Yes, my lord.
Okay. Then in 3 minutes?
Yeah, to carpet, my lord, my ladies. We want to make it very clear, perhaps not even a matter for this court to note, but this matter is of great national interest. And 1 year to an election, my lord, my ladies, and taking into account what I earlier noted, the granting of the application by the respondents, setting aside the conservatory orders issued by this court, and being apprehensive of the necessary actions, next actions, my lord, my ladies, you should not take it against us when we issue statements on caveat emptor. Let the buyer be aware. All of this because national interest must be protected. We managed to stop the sale of the Jomo Kenyatta International Airport until President Ruto himself had to come out and say, stop it. I want to invite him to consider the same statement in view of the great interest this matter has evoked. Because my learned friend wa Tanzania anamuita wakili msomi. Wakili msomi mwenzangu anawaita majina yao, lakini ukweli ni kwamba they serve under one authority, the President of the Republic of Kenya. I invite him to exercise prudence and high consideration of national interest. His predecessor, Uhuru Kenyatta, could not have dared to touch Safaricom. We rest our case, my lord, my ladies.
All right. Thank you very much. There was another petitioner.
Yes, my lord.
Yes, Kerala, do you wish to make any submission and do not repeat what has already been stated, eh?
Yeah. Give me like 2 minutes, my lord. I read it.
2 minutes?
Yeah. I want land raise court for previous orders. Na niko hapa kuunga mkono hii petition ya E051 na niko na huzuni, my lord, kwa sababu wakati tulienda serikali ilienda wa court of appeal, sikusabiwa na the relevant documents na nika complain, but they proceed to the matter in the court of appeal. Nimekuja hapa leo kwa kulia nikisema na nikiomba koti leo mchana ya leo, Safaricom is our heritage in this country, our brand that ikiuzwa iende kwa nchi ya kigeni hatutaweza kuipata tena. So kwa leo naweza omba koti ama niseme niko hapa kama Mkenya na nimekuja nikiwa binafsi, nikiomba koti isikie ile kilio ya Wakenya wengine milioni 50 wenye hawana uwezo wa kufika mahali hapa. Sina mengi kwa leo, but naweza omba koti isikize hiyo ombi. Asante.
All right, Santu Saidi. So is Ogola here now? Professor Ogola, are you here now? Right. Professor Ogola is not here. So I think now we'll now go to the respondents.
I'm told Professor is on hold, is waiting to be admitted to the lobby.
There's nobody in the lobby. I'm the one who is admitting people, and I've admitted everybody. I've admitted everybody. I'm the one admitting the people. And I keep on admitting while we proceed. So in which lobby? Because he's not in my lobby. So I think we assume that he is absent. After all, we were made very extensive and profound submissions on the entire case. So we proceed now with the respondents, John Ohaga, and also be brief, because we are going to read the submissions which have been filed and which we find to be quite detailed and comprehensive. John?
Thank you very much, my Lord, your leadership. I see that Kalonzo Musyoka Senior Counsel has departed. We have listened very carefully to the case of the petitioners.
Yes.
We have given consideration to the submissions as well as to the matters put forward in the amended petition and the supporting affidavits. My Lord, the respondent's case is simple and straightforward.
Yes.
In our respectful submission, the petitioners have built their case on the wrong legal foundation. They ask this court to treat this matter as a privatization program falling under the Privatization Act, and simultaneously ask that you treat it as a public procurement matter falling under the Public Procurement and Assets Disposal Act.
Yes.
My lords, both of those acts, at section 4 of each of those acts, exclude the sale of shares from the ambit of those acts. And we have set out the precise provisions in our written submissions. It is difficult to understand why the petitioners choose to ignore the statutory route created by Parliament for the sale of shares in a government-linked corporation. The first duty of this court, therefore, my lord, your ladyships, is to identify the correct statutory route for the sale of these shares. Being perpetrated by the respondents by insisting that the matter falls within a legislative architecture which Parliament itself has deliberately excluded.
Yes, continue.
The next issue we want to deal with, my lord, relates to Treasury's role in revenue raising and Treasury's authority to raise revenue or to mobilize non-tax revenue. The submission has been made that Articles 207 to 214 under Part 3 of the Constitution do not provide for the sale of shares as part of the ways in which government can raise revenue. My lords, that is a superficially attractive argument, but it is again a misconceived argument. Article 209 to 214 regulate taxation, charges, borrowing, guarantees, and public debt. But they do not say that government may never raise revenue from an investment. Indeed, my lords, all the court has to do is to go one article down, Article 206, which relates or recognizes that money raised or received by or on behalf of the national government may or should ordinarily be deposited in the consolidated fund unless a statute prescribes otherwise. Why would Article 206 provide or recognize money raised or received by or on behalf of the national government unless the Constitution itself allowed the government to raise revenue other than through taxation?
Yes, continue, John.
Article 206, my lord, is then given life or architecture by the Public Finance Management Act. Sections 11 and 12 of that Act then give the Treasury the mandate to formulate macroeconomic policy, to manage public debt, to mobilize resources, and to manage public finances. If the petitioner's construction of the Constitution, limited to Articles 207 to 214, was to be accepted, then it would render Section 87A of the Public Finance Management Act completely meaningless and would significantly erode Article 206, which itself recognizes that government may raise revenue. As my lord, your ladyships will appreciate, the Constitution requires us to give a purposive interpretation to its provisions, not an interpretation that would result in the negation of various pieces of legislation which have been enacted to give effect to the Constitution.
Yes?
The third issue we want to deal with relates to the attack on the cabinet approval, the parliamentary approval, and public participation. Well,
Yes?
the transaction has been alleged to have been conducted secretly in an opaque manner and without the requisite adherence to the provisions specifically of Article 10 of the Constitution.
Yes?
Well, we have demonstrated in the 3 affidavits sworn by the Cabinet Secretary
Yes?
that a sessional paper and accompanying explanatory material went to the National Assembly subsequent to the Cabinet approval. The Joint Committee of the National Assembly considered the sessional paper, undertook extensive public participation, and the National Assembly approved it by resolution.
Right?
We have set out a lot. 78 stakeholder institutions were engaged. Public participation forums were held across more than 30 counties. 32 sittings considered the valuation, the identity of the purchaser, questions relating to employment, governance, competition, consumer protection, data sovereignty, and national security. It is not the law that every objector who presents his views must have those views embraced unconditionally. The test, and I need not remind your lordship, your ladyship, the test is one of reasonableness. We have given you the Supreme Court's decision on British American tobacco for the proposition that public participation must be real, not illusory, and must provide reasonable notice and reasonable opportunity. In our respectful submission, that threshold has been met.
Okay.
There have been allegations of fraud against Parliament. No particulars have been supplied. And those allegations have not been proven. It is not sufficient to place rhetoric before the court and make allegations of such a serious nature as fraud. Fraud, as we know, must be pleaded with particulars and must be proved.
Judge, you should be winding up, eh?
I am making progress towards winding up a lot.
Yes.
Let me next deal with the question of pricing and valuation. Because clearly, this is at the center of the petitioner's case. But it is also where the case is most ambitious, but least proven in our respectful view. What the petitioners ask this court to do is to sit as a valuation tribunal. This court is not a valuation tribunal, neither is it a valuation committee. The court's role is to assess the legality of the transaction based on the material placed before it. Mr. Lempar, to his credit, has looked at the share price this morning. What?
Yes.
Oh, he's even bought the shares this morning. Congratulations.
Yes?
And referred you to section 60 of the Evidence Act. I did not remind the court that the material time is December of 2025, when the transaction was contemplated and sought to be entered into by the government. Share pricing is dynamic. It is affected by numerous factors. And if the petitioners had not interfered with this transaction through the launching of this petition, to which they're perfectly entitled, this purchase price would have come in 6 months ago.
Yes?
So it is not sufficient to cite today's price and allege on that basis that there is an undervaluation. Neither is it sufficient to ask that one expert's opinion be preferred over the valuation commissioned and relied upon by the government. The court's role is to determine the legality of the sale, taking into consideration constitutional and legislative provisions. And to determine whether the price in the circumstances agreed by the government is so abnormally low as to point to perversity by government. In our respectful submission, the evidence placed before you by the Cabinet Secretary is to the effect that professional transaction advisors who are engaged, they considered all the factors, they had consideration to the numerous valuation methodologies, and they advised the government on what they considered to to be a reasonable price with a premium based on the identity of the share, the proposed purchaser. In our submission, that price does not disclose any illegality. We have placed before the court comparative jurisprudence, specifically the decision of the Supreme Court of India in Balco Employees Union versus Union of India for the proposition that the court does not determine whether the valuation committee's price was correct, but examines whether proper procedure was followed and whether the price was arbitrarily low and unacceptable. The petitioner's expert opinion is not proof of unconstitutionality. It is at most, your ladyship's, my lord, a different professional opinion. Beyond offering his opinion on what the price ought to have been, Mr. Nyakera has proceeded on the assumption or on the theory, on the theory that the price would be higher if M-Pesa was to be carved out. But M-Pesa is part of Safaricom. It is a unified company. It is not being sold separately.
Yes.
And the suggestion, therefore, that a higher price would have been obtained is based on a faulty theory that we submit this court should reject. In the end, my lord, your ladyship, the petitioners have not proved an undervaluation. They have just proved that they would prefer a different model. That is not sufficient to override the cabinet approval and the National Assembly's approval, both of which are integral to Section 87A of the Public Finance Management Act. Lastly, let me deal with the issues relating to data sovereignty, national security, Articles 35 and 65, and the question of competition.
Yes.
All of these arguments, my lord, proceed on the mistaken basis that sovereignty, data protection, national security are preserved by shareholding. Look, the sale of these shares does not suddenly dissolve Kenyan municipal law. Sovereignty is exercised through law. Safaricom will continue to be subject